What if I am the owner of animal myself? And if I inflict maiming or inflict any sort of do any mischief on the animal, then is there an offense at all? And I think these are very important things that has done, wherein the courts overall have given out and said that, well, we're not looking section 428 and 429 as just offense the owner of a particular property, but should be looked at the offense against the society as well as the animal cruelty in itself. What you also saw was there were certain offenses with relation to health, with relation to negligent contact to an animal's in possession, which is 289, where all of these offenses were not really tied to animals. It was clear that there was a view that animals were property, some were valued higher than the others. So in the mind overall, when the Indian Penal Code was written, it wasn't that all animals are equal, all animals suffer, and hence there has to be equal protection given to all animals against any sort of cruelty. There was a value proposition that was brought in. If an animal was about 10 rupees, then it had certain value. If an animal was about 50 rupees, it had certain value, hence higher punishment. However, if you valued the animal below 10 rupees and it wasn't in the set category of animals, it really wasn't an offense, or even to this day, it really isn't an offense under the Indian Penal Code to in the chapter of mischief within the purview of section 428 and 429 of it. However, in 1890, we saw a specific legislation that was brought in, which is the Prevention of Cruelty to Animals Act 1890. Here again, the definition of the animal was pretty narrow. It only covered animals which were domestic or captured. So if an animal was neither a domestic animal, nor it was a captured animal, so purely a wild animal, the act did not apply at all. The punishment for cruelty was more on public places. It was very, very important. If an offense took place in private behind the screens where public did not see, it wasn't an offense under the Prevention of Cruelty to Animals Act. From today, when we look at it, it says it makes no sense. What difference does it make to a dog whether you're starving the dog in public view or you're starving the dog in private view or in privately with nobody seeing? However, in that particular point of time, what we really saw was be it ill treatment, beating, overriding, exposing to pain and suffering, unnecessary and cruel. All of this was with relation to only when it happened in a public space. There was no mention of private spaces at all. Killing is in unnecessary cruel manner was brought in. If you cause a sick animal to work, it was a punishment. And even in that particular law, animals could be sent for treatment to an infirmary by a magistrate, pending prediction before himself. And it also said that you cannot permit a deceased animal to go by large. If you again looking at it from the lawmaker's point of view, at this particular point of time, it's less to do with the fact that one has to prevent animal suffering. It was more to do with the fact that is animal suffering being seen? If animal suffering was being seen, and then in a public space, it was considered an offense under the old act, that is the Prevention of Animals Act 1860. If it happened in a private space, it wasn't considered to be cruelty overall. You also see, for example, this is section 3. It says, this is the old act. If any person in a street or in any other place, whether open or closed, to which public have access within sight of any person in any street of such place. So for cruelty to be made out, the case for cruelty to be made out in the 1860 legislation, it was extremely important that the cruelty had to be done in an open or a closed place in a street or where public have access or publics were able to see. At that particular point of time, they said that the offense was up to 100 rupees. Now you must realize in 1890, 100 rupees was a lot of money. It was a lot of money, or with an imprisonment with a term which may extend to 3 months or both. This was the old act, section 3. There was certain law. For example, in this case, the Calcutta High Court was considered a question. So there was a kind of a dye that was used for printing, which was made out of the urine of an animal. So what they would do is that to get that really thick consistency of the color, they would only feed these animal mango leaves in order to make a dye. In this particular case, when you really look at it in 1912 and 1913, The question that really revolved around was that whether the suffering that was being inflicted on the animal, where this animal was only fed mango leaves and no other food, whether this was happening in public view, whether it could be seen in street or not. In today's discourse, if a discourse was like, well, is suffering happening in front of our eyes or not, maybe we would be like, why, what are you talking about that? But you will realize that when you look at 1912 and 1913, the question that really revolved around was that whether this could be seen from the public or not. In Emperor versus Ibrahim, the Bombay High Court found that the act of stitching up the eyes of 5 cranes in a railway travel was not covered under Section 3 because the act had happened prior to travel and not in the manner in which the travel took place. So you can say if you are taking a crane bird and if somebody is stitching up the eye of these birds, today you would say, oh my God, it's so cruel. But there, the Bombay High Court is really saying that because the suffering or the cruelty did not happen in public space, the act happened prior to travel, hence it is not considered as cruelty. Another one here, it is said that when an animal which was starving and it was like actually abandoned on the street, it was said that the Bombay High Court held that there was no provision that prevented the abandonment of the animal. That it was starving subsequently was not the responsibility of the owner at all. Law was narrow, law was limited, and even from the court's point of view, it was being interpreted extremely narrowly, and animals were not focused. Be it the duty of care of a person who is in charge of the animal, be it the duty of the care of the person who is the owner of the animal, everything that we start seeing in subsequent legislation, everything that we start seeing in subsequent legislation and litigation and judgments as well is not seen in these earlier judgments, where you basically are saying that that the law was being read very, very narrowly. Developments of post-independence. In 1954, the MP Rukmini Devi Arundel introduced the private member bill in the Rajya Sabha, and it was called the Prevention of Cruelty to Animals Bill of 1953. At that particular point of time, the bill called for an adoption of law which suited for the Indian context. At that time, Rukmini Deviji spoke about the issue of hunting, scientific experimentation, use of animals in performance. She also spoke about animal sacrifice. During her speech, she made some really important point. And again, looking at it from 1953's point of view, you'll see it's really progressive. She says, do we believe in a fundamental principle that we must not get benefit for ourselves at all cost? Are we going to get benefits at all costs? Do we believe that animals are our slaves? Do we believe that their feelings do not matter? That is the question that we have to answer for ourselves. So in a really impassionate speech, she asked that these are the questions that needs to be done. Then Prime Minister Pandit Jawaharlal Nehru is in Rajya Sabha at that point of time. He's moved by the speech that is made by Rukmini Devi Arundel. And then at that point of time, a committee is set up, a joint parliamentary committee is set up, comprising of 45 members. And the joint parliamentary committee delivered a report which caused the government to revise its bill. The law eventually became to be passed as the Prevention of Cruelty to Animals Act of 1960. We'll see that when the 1960 law was passed, there was a thought, there was a legislation process and the thought, and it's extremely important when you really look at the parliamentary debates. And as students of law, I strongly suggest that whenever you're reading or understanding any legislation, it's extremely important to just read the parliamentary debates, because when you read the parliamentary debates, you understand what was in the mind of the lawmaker when they do that. Now let's dwell deep and see what was in the mind of the lawmaker when they did this. The Agriculture Minister S.K. Patil, when he presented the bill, he said, the law is not perfect. So there was an acceptance saying that while we are doing this Prevention of Cruelty to Animals Act, it's not perfect, but it's an attempt to deal with a complex and widespread problem. So they had applied their mind. They had realized that India was an agrarian country. There was a lot of conflict with relation to use of animals. At that particular point of time, we had to weigh our development and growth along with the prevention of cruelty to animals. And he said that, well, this is not a perfect law. And the law, what was being done was to deal a really complex and a widespread problem. And they also said, we also need to do a balancing act. There's human needs on one side, there's a cruelty on the other. At that particular point in time, there is also called to impose vegetarianism, and that's completely rejected by the parliament. The emphasis is on two parts. It's humanitarian as well as criminal. Even though the Prevention of Cruelty to Animals Act is a pure criminal legislation, it creates offenses and it creates what is the punishment for it. You will see that it has got all tenets of a welfare legislation as well, because there are certain provisions under the Prevention of Cruelty to Animals Act, which basically talks about general well-being of an animal, and it looks at it from a humanitarian perspective rather than a binary black and white saying that this is offense and this is not an offense perspective when it comes to the criminal law. So the concern was that whether criminal law was the only way to get about the issue. And I think today, more and more, this is something that we need to ask. Is criminal law the way around to get around various societal issues? At this particular point of time, we've become so complacent, or like we basically demand for criminal law for everything. But when you really start looking at criminal behavior and various studies, you realize that criminal law is something, but then criminal law not necessarily creates the deterrence for every sort of offense. For anything to be creating a deterrence, you need to have two key elements, right? One is that the punishment has to be adequate. Most importantly, the punishment has to be certain. But when you start looking at the Prevention of Cruelty to Animals Act and legislations as such, there is really no deterrence these days. One is because there is really no certainty of punishment, and the quantum of punishment is also very low. And hence, it's important to start looking at the issue overall and see, is there a way in which one could create civil liabilities over people who hurt the animals? And I think that's a topic for a discussion at any given point of time later. But it's important for us to kind of keep looking as to, when we're looking at a complex issue like prevention of cruelty to animals, are we just looking at it purely from a criminal law point of view? Or are there certain other ways in which we can also hold the perpetrators responsible? Many owners of animals are kind. They say that the presumption should not only be negative. Under the Prevention of Cruelty to Animals Act, there are certain negative presumptions where the burden of proof is actually on the accused rather than the prosecution. But at this point of time, here the parliamentarians are saying that most people who have animals with them are really kind. Hence, the presumption should not be that of negative. It sought to create a long-term behavior change. Along with the Prevention of Cruelty to Animals Act, if you were to start looking at the Wildlife Protection Act, which was passed in Indira Gandhiji's regime in 1972, you kind of see the change in tone. The change in tone in which you see that the presumption is that every accused is actually guilty. They say that there's a presumption of guilt. And as long as, if, for example, in a hunting case, all that the prosecution has to prove is that there was a simple custody. So let's say somebody has a leopard skin. All that the prosecution really has to prove under the Wildlife Protection Act of 1972 is that the accused had simple possession of that skin. The prosecution does not have to prove anything further. The burden then shifts upon the accused, that the accused has to now prove that he was in legal possession of that particular leopard skin. So again, it's interesting when you start looking from how the Prevention of Cruelty to Animals Act itself evolved. The earlier act, which basically said that it had to happen in public space. There was no overall humanitarian aspect to it at all. Under the Prevention of Cruelty to Animals Act 1960, there is overall a concept that the presumption should not be negative. When you look into the Wildlife Protection Act of 1972, the coin is completely flipped, and there is actually a presumption of guilt in the act itself. Going further, you see that there is also emphasis on positive aspects as well. That is the creation of the Animal Welfare Board of India. Even though this is a pure cruelty legislation and also a pure criminal legislation, they go ahead and establish an Animal Welfare Board of India, a statutory body on whom I served as a member as well as a co-opted members for many, many years. And there the role really was that the AWBI's role was to play a leading role in standard setting, education, and look at positive change. It was an advisory. The government was to go by its advice. Section 3 of the Act also created the duty of care on human beings. If you can look back at the older act, the citation that I said, where the court said, well, it doesn't matter that even if you abandon the animal, then it's not your responsibility. Whereas in Section 3 of the new act, that is the Prevention of Cruelty to Animals Act 1960, there is actually a duty of care on every person who is in charge of an animal to take care of the animal. In the thing, you also see that there's a charter of rights that have to be given. There's also a charter of duties for the human beings, and also there is an understanding that it might not be possible to prosecute all offenses. Typically, when we write criminal law, the drafting is that you write it in such a way that you want to prosecute every single offense. You want to kind of make most offenses compoundable, so that there is some sort of compounding that is done, so that there is immediate punishment of when an offense takes place. And you'll actually see that under the Prevention of Cruelty to Animals Act, a lot of offenses, actually no offenses are compoundable at all. And that's one of the many reasons when you look back as to why did they not add a provision of compounding was in 1960, they thought, well, we don't want to make every offense punishable. We understand that it's a slow process. We want to create the deterrence that you could be punished and prosecuted. However, the larger focus was on education, standard setting, positive change, so that you're able to nudge this change within the society overall. There were many calls for greater definition in terms of law as well at that point of time. But when you really look at it from a property aspect of view, the same jurisprudence of dealing with as animals as property, it continued here as well. And most importantly, the doctrine of necessity and unnecessary pain and suffering kind of got reflected. So it was accepted that it is impossible not to inflict any cruelty on animal at all, because even if you are using an animal for agriculture, there is obviously some amount of suffering that is inflicted. Many times, even when people have pet dogs at home or pet animals at home, there's obviously some sort of cruelty that happens. However, when you really look at it, they said that the aim of this legislation was to prevent unnecessary pain and suffering, and the doctrine of necessary kind of came in. But the question that really comes in is that when you say that only necessity pain can be caused, who allows that particular necessity pain? As in, who says, well, this suffering is necessary, this suffering is unnecessary. And when you lead, there's a huge amount of interpretation left to the magistrates. For example, when you look at the definition of the word animal itself, under the Prevention of Cruelty to Animals Act, basically all animals other than human beings are considered to be animals. It's a really, really broad definition. Does that mean that if there is a pest control and somebody is killing an animal, you could potentially be prosecuted? If you read the law really strictly, obviously yes. However, when the doctrine of necessity brought in, it was up to the magistrates, and the magistrates could decide whether one particular thing was necessary or it was broadly unnecessary. Animals broadly were defined as living creatures, and not human beings that are not human beings. The provisions were applicable to both domestic as well as captive animals, and it was in line with the common law distinction that was there. The owner defined into person who was in possession with or without consent of the animal. So it was very interesting. So even, let's say, in a situation where somebody goes and steals an animal, and if the thief has the possession of the animal at that particular point of time, as per the definition of the Prevention of Cruelty to Animals Act, the person who is in possession becomes the owner of that particular animal. The duty of the person having care, it says that the duty is not necessarily just restricted to the owner. Any person who has even in charge of an animal or who is in care of the animal, they all have to take reasonable steps to ensure its well-being. Then in section 11, they brought in a laundry list. The section first, and I think it's a really beautifully drafted section, they said that overall, the first, generally, you cannot cause unnecessary pain and suffering. And then specifically, they gave a list of things which says that, well, you can't use infirm animals for work. You can't unreasonably administer poisonous substance. Again, they said that unreasonably administered poisonous substance, because they realized that maybe at some point of time, mercy killing had to be done for animals, then it would be reasonably administering poisonous substance. A reasonable opportunity of movement, as in it was given that animals had to be tethered, they probably would have to be kept inside a shelter, but you had to provide reasonable opportunity of movement. And obviously the law did not define as to what is a reasonable opportunity, what is sufficient for food. It did not define what is necessary cruel manner or unnecessarily cruel manner. All that was left in the hands of the magistrates when the matter was came before them to decide and adjudicate whether it was unnecessary, whether it was reasonable, it was sufficient. All of this was given to them. There are certain clauses that specifically applied for owners as well. The owner is deemed to have committed an offense if he is not doing if they don't exercise reasonable care and supervision. It's very important. So there's a deeming clause as well. So there's not only a negative punishment. So example, if you are starving an animal, but if you are the owner of an animal and you don't take necessary action or care and supervision to ensure that the animal is not starved, even if that particular animal is not within your care and custody, even then you are still liable to be prosecuted under the Prevention of Cruelty to Animals Act. And these modern day and age, there could be a lot of things, as in people engage dog walkers these days to take dogs out for a walk. These dog walkers are probably overworked. They end up beating the dogs or like not giving food to the dogs. Or you just say some helper at home to feed the dog. The helper just got busy watching YouTube, forgot to feed the dog. Or at all of those particular time, what you see is that even though the cruelty might not have been inflicted directly by the owner, because the owner failed to exercise reasonable care and supervision, the owner is then considered liable under the Prevention of Cruelty to Animals Act. There are certain places where it says that if there is some suffering that is necessary for humans, let's say killing an animal for food, there again, as long as you are not doing it in an unnecessary way. For example, in modern days, we say that if an animal has to be killed for the food, it has to be cared well, it has to be stunned before slaughter, and all of those things. Or if you're housing an animal, then don't house the animal in tiny cages, provide them in larger enclosures like aviaries and barns so that the animal is able to express natural behavior. Overall, it was recognized that there are certain amount of cruelty that is done in terms for necessity of animals. However, even necessary for food for human beings. However, even at that particular point of time, it was upon the owner to ensure that there wasn't any unnecessary pain or suffering. Then let's look at this. So there were also provisions in relation to euthanasia. So again, magistral powers, you see that magistrate may order destruction of a suffering animal. In case of a conviction, the magistrate, if the owner does not consent, if there is a conviction, the owner does not consent for the animal to be euthanized, the magistrate taking the opinion of a vet in charge can also euthanize. In some cases, it is it's not necessarily the offense must be completed. So you're not necessarily waiting for the offense to happen. Even if the magistrates have reason to believe that an offense is being committed, then there is an option that the animal can be taken. For example, let's say in a cockfighting or dog fighting, which is illegal. So you don't have to wait for that particular point of time. So, I remember a lot of times during Shankranti or others in Andhra Pradesh, where there is huge cockfighting rings that is set up, and people call the police and say, well, there is a cockfighting ring set up, come and do something. And they'll say, oh, well, the offense still hasn't taken place, so we can only come when the offense is taking place. So that's actually not how the Prevention of Cruelty to Animals Act is written, where they actually provide magistrate saying that even if you have reason to believe that an offense under this act is taking place, then you could take action. It indicates that the concerns of owners are not paramount, and where again the precedence has to be given to the magistrate. Under section 35, there are certain directions that are given for the treatment of care. It's said that the state government should set up infirmaries for treatment. Infirmaries are basically animal shelters, gaushalas, pinjrapols, however you would like to call them, depending on which part of the country that you are. They should set up infirmaries for treatment and care of animals with whom offenses have been committed. The magistrate may direct that the animals be sent for infirmary pending production before it. Once recovered, an animal must be sent back to a pinjrapol or like a retirement home. It can also be destroyed if it is incurable, and most importantly, there was also a civil liability created on the owner, that the cost of it has to be paid by the owner, and at any given point of time, it can also be sold to recover. Obviously, under the old act, you will see that the animals could actually be sold to recover, and that kind of defeated the entire purpose of the act. The Supreme Court, much later on, in the matter while dealing with the Gadimai slaughter issue in Korimoleki versus Union of India and others, struck down and said that if you're rescuing an animal pending litigation, the custody of the animal should always be with an animal welfare organization or a hospital. You cannot just give the custody of the animals pending to the accused themselves. And second, most importantly, at the end of the trial, and once the animals have recovered, you have to adopt the animal out or find a retirement home for the animal, but not necessarily just sell the animals for recovery. So you'll see that the Supreme Court stepping a few steps beyond what the law required when it came to dealing with custody of animals. There are also certain directions with relation to treatment of the animal. If a person, this is very important, right? There is a fundamental right for you to own something. But then at this point of time, they said that even if you're an owner and if you are found that, upon conviction, they may forfeiture the animal. So they can say, well, you cannot have this custody of this animal, and even say that you cannot have any custody in future. So you could say, it's not just about this one particular animal upon whom you have inflicted suffering. They say you cannot have any animals at all, and the courts can actually pass that particular thing. It's very important, especially for repeat offenders. It could be, let's say, illegal pet shops or dog breeders who constantly keep breaking the law. So what happens is that they break the law, there is some sort of action on them, these animals are taken away, they again go, bring a new set of animals, and they break the law. However, the Prevention of Cruelty to Animals Act 1960 created a system where the magistrate could say, well, you cannot have any animal in your possession for a given period of time or even indefinitely. And what's again interesting is that each of these provisions have been challenged for their constitutionality, and they've been upheld, that even though they create certain restriction upon the rights of a human being, sometimes even to carry on their profession, saying that, well, if you can't have access to the animal, then you can't really carry on the profession. And the courts have now balanced on to say that it's reasonable to place those restrictions on the fundamental rights to further the cause of preventing the suffering of animals. There's also formulation of rules. Obviously the lawmakers realized that they couldn't cover the entire ambit of suffering, and human beings can be pretty creative when it comes to inflicting suffering on animals. So they gave the power to the central government to formulate rules, and the central government then on has made a lot of rules, be it with relation to brought-in pack animals, for animals who are used for carrying goods. There's a transport of animal rules. There's an animal birth control rules with relation to control of street animal population. And these rules interpret the provisions of necessary, unnecessary, and cruelty. Now, coming quickly on to some of the important judgments, and if there is one judgment that anybody who is interested in animal law must read, is AWBI versus A. Nagraja. This is a division bench judgment by the Supreme Court, authored by Justice Radhakrishnan, and they make some really giant leap when it comes to jurisdiction of writs overall, and most importantly, when it comes to just jurisprudence of animal rights. Article 21 of the Constitution, while safeguarding the rights of humans, protects life. The word life has been given an expanded definition, and any disturbance from the basic environment, which includes all form of life, fall within the meaning of Article 21 of the Constitution. So far as animals are concerned, in our view, life means something more than mere survival or existence or instrumental value for human beings, but to lead a life with intrinsic worth, honor, and dignity. Extremely important words, heavy words used by Justice Radhakrishnan. He says that if you have an animal life that is being led, that doesn't mean that it has to be just mere survival and existence for instrumental value. As long as the animal is able to do something for human beings, it's all right to survive. That's not what it was. As for example, when we looked at the earlier cases, they said that as long as the animal was alive and the animal was only being fed mango leaves and you were able to make a dye, it was all right because the animal was providing for instrumental value for human beings. And in Nagaraja's case, the Supreme Court says, Justice Radhakrishnan says, well, an animal's life is not just mere survival or existence for instrumental value for human beings, but it is to lead with an instinctive worth of honor and dignity. It says that Section 3, the duty of the person having charge, Section 11, that's cruelty. Section 22 of performing animals have to be read in context with the purpose of the act and must be given an expansive interpretation. Earlier, we saw narrow interpretation. The Supreme Court now asks for an expansive interpretation. Section 3 and 11, when read with Article 21 and 51 AG, give rights to animals to life, dignity without cruelty. And they say that these 5 freedoms have to be read. That's freedom from hunger and thirst, malnutrition, freedom from fear and distress, freedom from physical and thermal discomfort, freedom from pain, injury, and disease, freedom to express normal patterns of behavior. So again, very important, what the Nagraja judgment said that only acts of necessity is to be provided, and they said that entertainment is not necessary. And most importantly, the judgment here said that a statutory law overrides culture and tradition, because a lot of animal suffering that happens in the name of culture, happens in the name of tradition. And they say, well, we've been doing this for generations, hence it should be allowed. And the Supreme Court in this judgment said that if there's a statutory law, that has to override culture as well as tradition. How has this been there? And so we've kind of done quickly jump from the legislation. We've seen as to what the law laid down by the court has been. But overall, when we go back and see in 1960, when the agriculture minister, he said that this is something that we are doing. It's not perfect. We need to relook. Sadly, it's 2020 now. From 1960, the parliament has never had the time to look into this. The Law Commission of India has asked multiple times that this law needs to be reviewed. The multiple judgments of the Supreme Court, where the Supreme Court has implored upon the parliament to relook at it. Sadly, this has never ever been on top of priority of any government. And many a times, if at all there has been any review done, has been to weaken the legislation rather than making it strong. The law reform process has been very, very slow. Unfortunately, many conceptions that prevailed in early legislation continued, especially the thing with unnecessary suffering. Even after Justice Radhakrishnan's judgment, the underpinning was unnecessary suffering. And that becomes a big problem because unnecessary is defined by whoever who wants to use it. So if you want to exploit an animal, you could create a million reasons as to why it is necessary of them. Many issues that have been attempted to resolve with the new resolution. Obviously, relationship with ownership and cruelty was done. So even if you're an owner, if you're inflicting cruelty, you could be punished. The concept of public and private places was taken away. Wherever the cruelty takes place, be it public places or in private places, it's still cruelty. There is no restriction on the nature of animals. Even if one causes suffering to a wild animal, you can be prosecuted under the Wildlife Protection Act and can be prosecuted under the Prevention of Cruelty to Animals Act. There's no differential of value. Under the Indian Penal Code, we saw about 10 rupees one punishment, above 50 rupees one punishment. Here, all animals are equal. They're all looked at the same. It could be a dog or a tiger or a bullock. All of them are seen equal. And if you inflict cruelty, there is same punishment that is done to you, both positive acts as well as negative acts. So if you not only inflict cruelty, but even if you don't take reasonable measures to prevent cruelty, then it is also an offense. The law contains a lot of limitations on ownership. It fails to fully resolve the fact that animals are living beings. There's a large role for magistrates to play and protect the animals overall. The terms that they need to interpret is unnecessary pain and suffering, unreasonably administers, unreasonable time. I could give like a huge list of things where there's a huge discretion provided upon the magistrates. It overall is that one has to read the rules, understand the law, and then it is there. The decision of the Supreme Court in Nagraja also allows for an expansive interpretation, and that gives a huge tool to the magistrates overall. But even with all of this, the penalty remains low. It's like 50 rupees. So we saw that on the earlier act itself, they had brought in 100 rupees. In 1960, they brought it down to 50 rupees, and even to this day, it's 50 rupees. So many a times, the auto rickshaw charge for the accused to come to the court for one time is way more than what the court actually ends up being fined. So that's overall has been the problem. But to conclude, if I were to look at the evolution of the law, despite all its challenges, the Prevention of Cruelty to Animals Act has stood up to most of the challenges that has been posed. There are crucial protections contained in the Act, which are the essence and which are in essence the limit of ownership over the animals itself. The Act allows consideration of animal welfare to override that of the owner, and it also results in the ownership of the animals being forfeited. and magistrates have an extremely important role. So in the criminal justice system, in this particular act, as much as is the role of the police, as much as there is a role of the prosecutors, there is a burden that is provided upon the magistrates. And in Nagaraja itself, the Supreme Court says that the magistrate who is dealing this particular matter has to take the trusteeship and has to become a guardian of these particular animals while adjudicating this, and not just look at it as a normal case. So that's broadly the evolution of thing. As in, obviously, I could go on for many hours, look at the evolution of the Wildlife Protection Act, the Cattle Preservation Act, but I guess like this is a really top bird's eye view of what the legislation is, what the law intent was, and how it changed, and how the courts have looked at it. I'm now happy to take any questions that anybody might have.
Sir, thank you so much. It was a lucid presentation. I think after listening to you, one has to understand that it's high time that we should develop a sense of say scientific temperament as well as compassion towards the animals. Of course, we do have a couple of questions lined up. The first question is by Mr. Darshan. How has the government justified the cruelty done on dairy animals, that is cows and honeybees?
So as far as the dairy animals are concerned, there is actually a Prevention of Cruelty to Animals Act, uh, registration of cattle premises rules where it's required. And as a matter of fact, I moved the National Green Tribunal a couple of years ago, saying that the urban dairies were completely unregulated, and it's important that they are regulated. Again, Darshan, from the government's point of view, it's a balancing act. At one particular point of time, there's an act to fulfill the protein needs of the people. On the other, to ensure that there is less suffering on these animals. Obviously, solution to say, well, there should be no dairy at all, that doesn't make any sense from the protein need point of view. So what the government has kind of done is has the thing, but obviously legislation is one part. There's a very lax of enforcement of not just only this, most welfare legislations in our country. However, the National Green Tribunal recently, in a case that I had moved, in fact, you can look up at it, it's NG Jaisama versus Union of India and others, where the National Green Tribunal basically said that one would have to start looking out and look at not only from suffering point of view, the urban dairies cause a lot of amount of pollution, and it needs to be done. So I guess like that's with relation to dairies. As far as honeybees are concerned, there's obviously the science of insect suffering is still growing. Maybe at some point of time we will reach a point that you would say, well, it is insects can suffer, and if do, how you would kind of do it. Probably at this point of time, I would say the science isn't necessarily settled. So a lot of the times, this cruelty statutes are mostly on the vertebrates, and it's not necessarily on invertebrates, and especially with relation to insects. But maybe things will change. As I said, the law in 1960, as in the lawmakers were phenomenal. They gave the discretion to the magistrates. They didn't say vertebrates, invertebrates, insects. They said anybody who is not a human being, who is an animal, is broadly an animal. So maybe as things evolve, the courts can evoke on other issues as well. But definitely with the dairy one, if you're interested, you should look at the NGT regulations, and there is a certain amount of movement that's happening, basically dictated by the NGT.
The next question is posed by Mr. Abhishek Chowdhury. His question is, what if someone has a record of animal abuse, but he wants to have a pet again? Will the Indian law value his reformation by any chance?
So just having a conviction overall is no prohibition on ownership of pet. So there has to be a specific order. So the way it works is that if you're convicted of an animal suffering, the prosecution during this time of conviction has to make an application to the magistrate asking it to pass an order saying that you cannot have, the accused cannot have, or at that point of time, any further custody. And there is a particular given time that is given, and maybe it's very odd because you can't revise. There is some provision where you can also revise, so you can make an application before the magistrate, because the general rule is that the magistrate, once they give an order, the magistrate can never revise their own orders, right? As in, there is no revision power that is given to a magistrate. However, in this case, the says that, upon an application, they can either extend, decrease the time. So there's obviously that. However, under the Prevention of Cruelty to Animals Act pet shop rules, if you are convicted of any sort of animal cruelty, and if you apply for a license to set up a pet shop or a dog breeding center, then you are prohibited. And that's been challenged, and that's been upheld by the court, saying that it's a reasonable restriction, as in you're basically having custody of these animals, and if you've been convicted, then you should obviously not have further anything to do with these animals further. So when it comes to the trade of it, there is an absolute prohibition without a specific order of the court. However, if you're just having custody of the animal, you're only prohibited when a magistrate makes a specific order prohibiting custody of the animals.
Right. Thank you, sir. We have 3 to 4 more questions lined up. If you have time, I would go ahead.
Sure.
Quickly going ahead, we have a question from Mr. Suman GS. In light of A. Nagaraja's decision, if a state enacts a legislation banning animal sacrifice, would such legislation be constitutionally valid?
So many states have actually passed legislations banning animal sacrifice, and Karnataka happens to be one of them. In fact, there is a by Karnataka Pashu Bali Adhiniyama, which basically prohibits any animal sacrifices. And in fact, if you go to any Mujrai run temples, you will actually see a board that is put out, a Mujrai's endowment department run temples. You will actually see a board which says that you can't sacrifice it. And this again was in states where there was no specific prohibition. It was dealt by the courts, and there are two very important judgments on this. One by the Himachal High Court and other by the Uttarakhand High Court. Now in Uttarakhand and both Himachal, both Pahadi states, animal sacrifice where male buffalo calves are killed is very, very common. And it went before, and in both of these places, the court said that if you are sacrificing the animal, it has to be as per the slaughterhouse rules, and it has to be purpose for food. And they in fact held and said that animal sacrifice does not fall broadly within the basic tenet of Hindu religion, and hence animal sacrifice was prohibited. So in Karnataka, as the law stands today, animal sacrifice is actually prohibited, and those prohibitions have actually been upheld by constitutional courts.
The next question is by Mr. Geeta Prabhu. How effectively these laws are implemented, and what is the rate of conviction in India with respect to animal cruelty?
So the rate of conviction actually is pretty high when charges are actually made. A lot of time the problem really is that because these are non-cognizable offenses, it's a laborious process for the police, right? As in they have to make an NC report, go seek the permission of the police, of the court, then come and do an investigation, file a report. But with the new trend that we are kind of seeing within the country, which is kind of disturbing, is that many a times when people are charged with cruelty, they actually come and plead guilty. And that kind of goes back to what I said earlier, where the auto rickshaw charges more than what the fine would be. So it's much easier for people to come and say, yes, I did it. So at worst, they get like a 50 rupees fine. They pay the fine and get it over with. And there was this very important case, or a very disturbing case rather, in Bangalore with Impinia. There was this lady called Ponnamma who admittedly took some puppies and crushed the puppies on the ground using her bare hands. And the Pina police filed a case. They did a thorough investigation, and the matter came before the magistrate. And she basically pled guilty before the magistrate, and the magistrate fined her 400 rupees or something like that. And as a matter of fact, there is a revision, there's an appeal, criminal appeal being filed and pending before the Karnataka High Court now. And I think Senior Advocate Mr. Sebastian is actually appearing on behalf of the animals, saying that it's wrong. You can't basically have such low fine, and a lot of time it again goes to the entire criminal justice system, right? As in, if the prosecutor had stood up and said that no, it's too little fine, maybe there is also scope for imprisonment. Even a nominal imprisonment would send the nose. It's important, and also, so I guess like for the effective implementation of this, building awareness in police, prosecution, as well as the judiciary is extremely important. And that's why when I was in India, I would focus so much on building capacity, the National Judicial Academy and the state judicial academies, building awareness amongst the magistrates, work with the Department of Public Prosecutors, the Director of Prosecutors to say, if there is an animal case comes, stand up, speak up, ask, say that the possession custody should not be given to the accused, ask for a higher penalty. At that's the only time. Otherwise, from a magistrate's point of view, these matter come as petty cases. They look at it, people plead guilty, there's a fine, and that's it. The matter just ends at that point of time.
Sir, I have last three questions to ask you quickly. This is a question from Mr. Nikunj Sharma. His question is, since the PCA amendment has been pending for ages now, as a part of strategy, what would be your advice for the activists and organizations in India to do to push for the PCA Act to be amended?
Right. So obviously, write letters to your members of parliament, push, ask for more, ask for private member bills to be brought in, everything. But I would say one place that we've completely missed is actually looking at civil liability. So now let's say if you're a person who is actually hurting an animal, the custody of the animal is taken away. At this point of time, the owner just washes his hands off from this animal. There is really no liability on them at all. However, if animal protection groups were to go after these people who are suffering or inflicting cruelty in a civil way, in civil courts, and start asking for civil damages, I think that there is definitely something there. So I would say that start using civil. Similarly, if people are buying pet shops and there's a problem with pets that they've bought, use the consumer protection law because that's a really strong piece of legislation that already exists. Use the Food Safety and Standards Authority of India and the legislations around that in terms of food animals. So while we push for the act of a parliament to change, the thing is that a lot of people say, why can't the court just increase the penalty? But we know that increasing penalty is a sovereign function of the government and can only be done by the government and by the parliament. It can't be done by court by a thing. However, civil liabilities are not sovereign, whereas criminal liability are sovereign. So it might be important for us to look at, all right, can we go after civil liability rather than criminal liability overall?
Sir, Ms. Malini Sitaram wants to know, what is your take on unregistered dog breeders and how to tackle with the issue?
So the unregistered dog breeders are a huge problem, as in it's probably one of the cheapest business, right? As in find a dog, find a female dog, breed them, sell them for a couple of $1,000 on OLX or whatever platform. And that's basically what it is. It seems like the cheapest zero investment business, which obviously causes a huge amount of suffering. Like, sometimes these animals being kept in cages. Like, we rescued a Labrador in Hyderabad maybe a year ago. And this dog had never, ever stepped out of a cage in her entire life. A huge problem. However, there is a new law that is coming, which is basically the registration of dog breeders rule. The state board has to done. And interestingly, because of COVID, a lot of states have now actually passed orders that says that the pet shops as well as dog breeding cannot be opened without permissions from the Animal Welfare Board. That's a state Animal Welfare Board. So I think this is the right time to kind of ensure that when these businesses are anyway closed because of COVID, when they open up as per the legislation requirement.
So the last question for this evening, in fact, I've clubbed two questions into one. These are the questions by Mr. Yashas Karthik and Geeta Shri, students of PS University. What is the procedure involved in prosecuting a case involved of cruelty, number one? And the second part of the question is, does adding an express fundamental duty to protect animals increases the awareness among people to protect the wildlife? Does that happen?
Right. I'm going to take the second question first and then come to the first question later. So obviously, adding in fundamental duty has got a tremendous amount of value. There's a value in jurisprudence. There's a value in, especially with relation to common law when you're making. It gives the huge leeway to the judges because in Ames and others, the Supreme Court have said that the fundamental duties have to be read overall as a duty of the state and collective, and hence actually becomes a really valid reason for writs under 226 to be issued. So if the Article 51 AG wasn't there, would we be so successful in getting writs admitted under 226 or sometimes even under 32 of the Constitution? I would be a little bit skeptic on that. So just having that provision there in terms, which basically says that with wildlife animals, like, the section 51, Article 51 AG has a huge value from just the positioning locus point of view when you really look at the law of writs overall. Now, coming to your first one, as far as the prosecution is concerned, under the Wildlife Protection Act, there is a specific provisions that have been given. So those cases are actually run as a complaint case. And I'm sorry if people who are not within the legal profession, if this is getting too complex, but I'm again happy to, maybe you could set up a call with me later and I can explain to you the difference. However, broadly, the wildlife cases have to be dealt as a complaint case. However, the cruelty cases are normally run as a police case, but a lot of these are actually non-cognizable cases. So the way it works is an NC report is filed, that NC report has to be then given to the magistrate, then a permission for prosecution, investigation is taken, then an investigation is done, then a charge sheet is filed, and the same CRPC procedures kind of taken. The only place, so the general rule with CRPC is this, right? The CRPC is applicable wherever in cases of special legislation, unless the specific legislation has a specific provision which is contrary to CRPC, then the CRPC is not applicable. So, right, that's the broad principle in which we work. Because under the Prevention of Cruelty to Animals Act, there's a specific provision with relation to search, seizure, and how to deal with seized animals, then the CRPC provisions are kind of not applicable. However, as far as the police investigation is concerned, because there's no specific provisions of investigation, then the CRPC comes in. However, when you look at the Wildlife Protection Act, broadly CRPC is not applicable at all because there is provisions of arrest, there's provision of evidence. As a matter of fact, under the Wildlife Protection Act, even General Evidence Act is not applicable broadly in terms of corroboration because, for example, the statement of an ACF and above is actually admissible, whereas a statement of a police officer is not admissible in Typical Evidence Act. So both of these are special legislations, and so broadly to be run and prosecuted as per the CRPC. As far as the Wildlife Protection Act is concerned, it's run as a complaint case, whereas the PCA Act is concerned, it's run as a normal police case.
Thank you so much, sir. Dear participants, due to paucity of time, we would be stopping here with respect to question and answer session. Of course, sir, we have a couple of more questions. I think I'll be sending across those questions to you. And we hope that we get back a reply from your end. So thank you so much for joining us. I request my colleague, Professor Tejas, for a formal vote of thanks.
Right. Tejas, before you go, just one last comment for 10 seconds. I'll probably send Uday my Calendly link. It's a link where people could schedule like a 30 minutes call with me if they want to have deep dive into any questions that they may have. So I'm happy to share that. So if there must be some email database of everybody who has joined in. So if you please feel free to schedule a call with me. I'm happy to answer any questions that you might have. Obviously, I can do. However, I must say that there are some really good organizations. For example, just the Humane Society International in India. I strongly suggest that anybody who has the time, who's got more interest, to reach out to Humane Society International in India, to Shreya and her team, Alok and her team. So we're doing such a good job there. People who are based in Bangalore should definitely get in touch with CUPA and CUPA's counsel, Alvin Sebastian, who does this fabulous work. And there is also a postgraduate diploma in animal law offered by Nalsar School of Law, which I strongly suggest people who have keen interest to take. But I must thank PES University for giving me an opportunity to come and speak and share. It's been an absolute honor to be here.
Well, thank you, sir. It's indeed my privilege to have been asked to propose this sort of thanks on this occasion. Now, first of all, on behalf of Faculty of Law, PS University, and on my own behalf, I would extend a very hearty vote of thanks to our honorable speaker for the day, Mr. Jaisima NG, for his excellent coverage about the topic, evolution of animal cruelty laws in India. Thank you so much. Thank you very much, sir. And I would also express my gratitude for our dean in absentia, Dr. Sandeep S. Desai, who has constantly provided us guidance and support. I would also thank all the participants for their active participation. And I would also thank Professor Uday Simha for coordinating, and Professor Ranjit and Professor Pramod for helping and providing assistance. And ladies and gentlemen, we thank you very much for being with us. And it was a wonderful evening. Thank you, one and all.